My daughter called me on a Tuesday morning, her voice stretched thin in a way only a father can recognize. My son-in-law got on the line 30 seconds later. He told me he'd already spoken to a developer about my land. He said it was going to happen whether I cooperated or not. He thought 65 years of quiet living had made me soft. He was about to learn that quiet men don't become quiet by accident. They become quiet because they've learned to let their work do the talking. And I had one last project left to build. Before I tell you what I did, hit that like button and subscribe, and tell me in the comments where you're watching from. I want to know how far this story has traveled. Now, let me take you back to where it really began. The farmhouse sat on 80 acres of rolling Tennessee hillside, the way an old man sits in a favorite chair, settled, unhurried, belonging exactly where it was. My grandfather, Earl Calloway, bought that land in 1931 with 12 years of savings from working the railroads. He planted the first peach trees himself, digging holes by hand in soil that had never been touched by anything but rain and deer hooves. My father expanded the orchard, added the apple rows along the western ridge, built the barn from timber he cut on the property. And when I retired 4 years ago from 38 years of civil contracting, I came home to finish what they started. My wife Margaret had always called it the real house. We'd lived in 3 cities across our marriage: Nashville, Atlanta, Knoxville, following my work, raising our daughter Claire in rented apartments in suburban neighborhoods that all looked the same after a while. But every summer, every Thanksgiving, every Christmas that circumstances allowed, we came back to the farm. Margaret would spend her mornings walking the orchard rows, cataloging the wildflowers that grew between the trees, sketching plants in a worn leather journal she kept on the kitchen windowsill. She had a gift for noticing things other people walked past. She noticed the patch of wild ginger near the creek. She noticed the pair of red-tailed hawks that nested in the same oak every April without fail. She noticed the way the light came through the peach blossoms at 6 in the morning in a way that, she said, made her believe in something larger than herself. She passed away 2 years before I retired. A stroke, sudden and complete. She was 61 years old and had been planning which fruit trees she wanted to add to the south field. I kept every promise I made at her graveside. I retired on schedule, moved to the farm on schedule, and spent my first year there restoring what time had worn down. I re-roofed the barn. I replumbed the farmhouse. I replaced the rotting fence posts along the lower pasture. I hired 2 local men part-time to help me bring the orchard back to producing shape, and by the second harvest season, we were selling at the county farmers market and to 3 local restaurants. I wasn't getting rich. That was never the point. The point was that the land was alive again, and I was living the retirement Margaret and I had planned together, just with one empty chair at the kitchen table. I should tell you about my son-in-law, because understanding him is important to understanding everything that followed. My son-in-law was a real estate agent. Not a bad one. He was actually quite good at it, in the way that a man who can talk to anyone about anything is good at selling things. He was charming in that deliberate, practiced way, the kind of charm you could feel working on you even when you knew what it was. He drove a truck that was too clean for a man who claimed to love the outdoors. He shook hands firmly and made eye contact a half-second longer than was natural. My late wife Margaret, who had a gentle way of being honest, once told me privately that he reminded her of the salesman who came to the door when she was a girl, the ones her mother would smile at politely while slowly closing the door. He never called me Howard. He called me Chief. The first time I thought it was a joke. By the 100th time I understood it was his way of acknowledging that I existed without ever quite respecting me. In all the years he'd been married to Claire, he had visited the farm exactly twice. Both times, he spent most of the visit on his phone, walking the edges of the property with an expression I couldn't quite name then, but can name now. He was appraising it. He was doing the math in his head, the way his kind always does. Acreage times, comparable sales per square foot, minus development costs, equals profit. He wasn't looking at my grandfather's peach trees. He was looking at lots. The first real signal came about 8 months before everything collapsed. Claire called on a Sunday evening, and we talked for nearly an hour about ordinary things, her kids, a vacation she was planning, a problem she was having with a neighbor's dog. But before she hung up, she mentioned almost as an aside that her husband had been talking to some people about tourism developments going up in the next county. Cabins, she said. Vacation rentals. Big money for landowners willing to partner with developers. I said that was interesting. She said he thought the farm would be perfect for something like that. I said I'd think about it. I didn't think about it. I dismissed it the way you dismiss a car alarm on the next street, briefly annoying, then gone. It was my land, my grandfather's land. It had one purpose, and that purpose was not a cluster of rental cabins for weekend visitors from Nashville. 3 months after that conversation, my son-in-law called me directly. It was a Saturday morning. I was in the barn sharpening pruning tools, and I almost let it go to voicemail. Something made me answer. "Chief," he said, his voice carrying that professional warmth that always made me feel like I was in a sales presentation. "How are you? How's the harvest looking?" I told him the peaches had done well this year. That's great, he said, not listening. "Listen, I've been doing some research. You know the Henderson property? Over on Route 12? Developer out of Chattanooga just paid $900,000 for 40 acres. 40 acres, Chief? You're sitting on twice that." I said that was quite a price. "It's a once-in-a-generation market," he said, and I could hear the energy in his voice, the kind of energy I'd heard from him before when he was closing something. "Look, I've got a contact. Good guy, serious money, already building out near Crossville. He's been asking about this whole corridor. If you were open to even just talking to him..." I told him I appreciated the thought, but I wasn't looking to sell. A pause. Not a surprise pause. A calculating one. "Nobody's talking about selling," he said. "There are structures where you could stay in the farmhouse and still receive income from the developed lay you've got 80 acres. You only use maybe 10 of them actively. The rest is just sitting there. You could turn that into a legacy for Claire and the grandkids instead of just a tax liability." I had never thought of my grandfather's land as a tax liability. I told him I'd consider it. I lied, the same way I imagine my grandfather would have lied. Calmly and without guilt, buying himself time to think. After I hung up, I went back to sharpening the pruning tools. My hands were steady. The whetstone made its familiar, soft sound. I thought about my grandfather's hands, which had looked a lot like mine by the time I was old enough to notice wide-palmed, deeply lined, the hands of a man who had made things. I thought about what my father had told me once, that the land was not something you owned so much as something you were responsible for. A stewardship, he called it. You received it from the people before you tended it, and you passed it on better than you got it. I didn't sleep well that night. I began to pay closer attention after that call. I paid attention to the way my son-in-law spoke about the farm when he came up in conversation. Always in the third person. Always in terms of what it could become, never in terms of what it was. I paid attention to Claire, to the way she sometimes mentioned his ideas with a careful neutrality that I recognized as practiced, the way a woman walks a line between two forces that both love her and neither one fully sees her. And I paid attention to myself, to the small erosion happening in me, the slight hunching of posture in conversations with him, the softening of my own words, the way I had started calling the farm just the property when talking to him, as if his language had started replacing mine. Margaret would not have allowed that. She had a saying, "A man who lets someone else name his things has already started to lose them." I started writing things down, not from anger, but from the same professional habit that had kept me accurate across 4 decades of contracts and project specs. I noted dates. I noted exact words. I documented every financial transaction I had made on the property, the restoration costs, the orchard maintenance, the equipment. I found my grandfather's original deed in a cedar box in the attic, along with my father's land survey from 1974 and my own most recent property assessment. I laid them all on the kitchen table one evening and looked at them for a long time, the way I used to look at blueprints before breaking ground. And then I made a phone call. Patricia Okafor was 34 years old and had just been named partner at an environmental law firm in Knoxville. Her father, James Okafor, had been my structural engineer on 3 major projects over a 15-year period. Brilliant man, exacting, absolutely trustworthy. He'd passed away from cancer 5 years ago. Patricia had his eyes and his precision, and I had watched her from a respectful distance grow into someone her father would have been very proud of. When I called her office, she answered herself. I told her who I was. "Mr. Calloway," she said, and her voice warmed immediately. "My dad talked about you all the time. You were his favorite client. Said you were the only one who ever read the whole contract before signing." I told her I had a situation I needed help thinking through. I told her it might be complicated. She said complicated was what she did. "Come in whenever you're ready." I drove to Knoxville on a Wednesday, the back seat of my truck loaded with the cedar box and every document I had pulled together. Patricia met me in her office, which had floor-to-ceiling windows looking out over the Tennessee River and walls lined with the kind of books that people actually use. She was small and quick-moving, with a stillness about her face that reminded me of her father, the face of someone who processes information faster than they let on. I laid everything on her conference table the same way I had laid it on my kitchen table. The original deed, the surveys, the financial records, Margaret's garden journals, which I brought not as evidence but because they were the clearest record I had of what the land meant. Of every named plant and nesting bird my wife had documented across 30 years of visits. I also told her about the calls. Every one of them. I read her my notes. Patricia listened without interrupting. When I finished, she was quiet for a moment. "Has he made any formal offers?" she asked. "Not in writing. Not yet. But he told me the developer had already been briefed on the property. He used the words moving forward." She nodded slowly, the way her father used to nod when a problem was coming into focus for him. "Mr. Calloway," she said, "he hasn't done anything illegal yet. But the direction is clear. And based on what you're describing, I don't think this stops at a conversation. A man who tells you something is moving forward before you've agreed to anything is a man who intends to make the agreement irrelevant." I told her I had come to the same conclusion. I told her I was not there to file a complaint or start a lawsuit. I was there because I wanted to build something that would outlast me, and outlast whatever my son-in-law thought he was going to do. She leaned forward. I told her about the Tennessee Century Farm Program. I had researched it in the weeks before our meeting, a state designation for working farms that had been in continuous agricultural operation within the same family for 100 years or more. My grandfather had started farming the land in 1931. That was 93 years ago. My family had never stopped. We qualified, and I suspected we'd qualify handily. Patricia's expression shifted into something focused and intent. "That's a strong foundation," she said. "But a century farm designation is recognition, not legal protection. It doesn't prevent a future owner from changing the use." I told her I knew that. I told her I wanted the designation as part of a larger structure, specifically a permanent agricultural conservation easement placed on the property through the Tennessee Conservation Fund, combined with a family heritage trust that restricted future transfer to blood descendants who agreed in writing to maintain the land's agricultural use. She was quiet again, but this was a different quiet. It was the quiet of a mind moving fast. "You'd be giving up the right to develop the property yourself," she said, "permanently and irrevocably. You understand that?" "My grandfather gave up the right to sell this land when he planted the first tree," I said. "He just didn't have a lawyer to make it official." Patricia smiled. It was her father's smile. She asked about my financial situation. I walked her through everything. My pension, my modest investments, the farm's income, my expenses. I told her I had no debt and no intention of taking on any. Over the next 2 hours, we built the architecture together. The Callaway Agricultural Heritage Trust would hold the property permanently. I would be its founding trustee, entitled to live on and operate the land for the remainder of my life. A conservation easement with the state would prohibit any subdivision, commercial development, or conversion from agricultural use in perpetuity. The trust charter would establish a board of 3, Patricia as legal chair, a local agricultural extension officer she knew, and myself with authority to approve or reject any residency request on the property beyond my own. There was one additional clause I wanted. Patricia raised an eyebrow when I described it, then wrote it down without comment. Any individual who wished to reside on the property for any duration longer than 72 hours was required to participate actively and documentably in the operation of the working farm. A minimum of 25 hours per week of labor orchard maintenance, harvest activities, soil management, irrigation with logs, submitted monthly to the board. Non-compliance, as determined by the resident trustee, was grounds for immediate notice to vacate. That's going to create some friction, Patricia said carefully. I expect it will, I said. She looked at me for a moment the way her father used to look at me when he understood what I was actually building. Then she picked up her pen. I'll have the initial draft ready in 10 days, she said. And Mr. Calloway, this is the most structurally sound thing I've built in a long time. I drove home through the hills as the late afternoon sun turned the ridgeline amber. For the first time in months, I didn't feel the low-grade dread that had been sitting in my chest like a stone. I felt the way I used to feel at the start of a project that I knew was right, not excited, not relieved, just certain. The following week, my son-in-law called again. His voice had a new quality to it, a controlled urgency, the voice of a man who has been waiting for the other person to move and is tired of waiting. Chief, he said, I need to talk to you seriously. I've got a meeting with the developer on Friday. Marcus Webb, good guy, been building in this region for 20 years. I'd like you on that call. I told him I wasn't available Friday. Saturday then. I told him I was going to be busy through the weekend. A pause. Longer than the last one. Howard, he said, and it was the first time in years he had used my actual name. I need you to understand that this opportunity isn't going to wait. Marcus has 3 other parcels he's looking at in this corridor. If we don't move now, this window closes. I'm trying to do something good for your family here. For Claire, for the grandkids. You're 65 years old. What are you going to do with 80 acres? I'm going to grow peaches, I said. The silence that followed was not the silence of a man processing an answer. It was the silence of a man deciding how hard to push. Look, he said finally, his voice dropping into something quieter and less performance-like, which was, I understood, meant to feel more honest. I've already had the property assessed. Marcus has seen the survey maps. He's interested, Howard. He's already interested. At some point, the conversation is going to happen whether you're in the room or not. I want you to think carefully about what you just said, I told him. Then I said goodbye and hung up. I stood in the kitchen for a minute, my hands on the counter, looking out the window at the orchard rows. The peach trees were in their summer fullness, leaves dark and heavy. My grandfather had planted the first of them from seedlings he drove 300 miles to buy. At some point, the conversation is going to happen whether you're in the room or not. That sentence told me everything I needed to know. This was no longer a conversation about opportunity. This was a man telling me, in the language of someone who had been very carefully polite for a long time, that he did not actually need my consent. He had simply been performing a courtesy call. I called Patricia that afternoon. She told me the draft was nearly ready. I asked if we could move to finalization by end of week. She asked if something had changed. I told her the timeline had accelerated. She said she'd have everything ready by Thursday. On Thursday morning, I drove to Knoxville for the second time. I wore my good shirt, the navy one Margaret had bought me for our 40th anniversary dinner, because some things deserve to be dressed for properly. Patricia was waiting in the conference room with the documents already laid out 3 stacks, each bound in a dark green cover with gold lettering. The Calloway Agricultural Heritage Trust. She read me the key provisions the same way a surgeon describes a procedure completely, precisely, without softening. The permanent transfer of the property and all structures to the trust. The conservation easement with the state. The prohibition on development, subdivision, or change of use. My right of lifetime residency and trusteeship. The board structure. The residency labor requirements. The grounds for eviction. And the final clause I had requested, that upon my death, the trusteeship would transfer only to a direct blood descendant of Earl Calloway, who formally accepted the terms of the charter and agreed in writing to maintain continuous agricultural operation. If no such descendant accepted within 2 years, the land would transfer to the Tennessee Conservation Fund as a permanent nature and agricultural preserve. I listened to all of it. Then I picked up the pen. My hand was steady. The pen moved across the signature lines the way a plow moves across known ground, purposeful, unhurried, following a line that was already there. I signed 11 pages. The notary stamped them in sequence. Patricia gathered the set with both hands, the way you handle something that matters. It's done, she said. I'll file with the county and the state today. By Monday morning, this trust is a matter of public record. The conservation easement will take approximately 3 weeks to fully process through the state office, but the trust itself is legally effective as of today. I told her thank you. She said what her father would have said. Good buildings outlast everyone who built them. I shook her hand, picked up my copy of the documents, and walked out into a warm September afternoon. The city felt far away from me even as I stood in the middle of it. I thought about my grandfather driving those 300 miles for peach seedlings, not knowing whether they'd take in Tennessee soil, planting them anyway, because some things you do on faith that the future will be worth it. He had been right. The 3 weeks between the signing and my son-in-law's arrival were the most settled I had felt in years. I went about my work on the farm without urgency or dread. I finished installing a new drip irrigation system along the South Orchard Row, a project I'd been putting off. I had Patricia's field contact, Dr. Marcus Webb from the State Agricultural Extension Office, no relation to the developer. My son-in-law had mentioned, come out to walk the property and begin the documentation for the Century Farm application. He was a slow-moving, deliberate man in his late 50s who had grown up on a farm himself, and he walked the rows the way someone walks through a place they recognize on a level below language. This is serious land, he said, running his hand along the bark of one of the older peach trees. You've got root systems here that are 60, 70 years old. People don't understand what that means. You can't buy this. You can only inherit it. I told him that was exactly what I was trying to protect. He filed his initial assessment the following week. The Century Farm application, he told me, was nearly certain to be approved. My son-in-law arrived on a Saturday at 11 in the morning. He had not called ahead. He pulled up the gravel drive in his clean truck, and his parents pulled up right behind him in a rented SUV. I had not been told they were coming. I was on the front porch, replacing a section of railing when I heard the vehicles, and I took my time setting down my tools before I walked over to meet them. He got out of his truck looking like a man who expected a negotiation and intended to leave with a contract. He was dressed like he was showing a property-pressed chinos, good boots that had never seen actual dirt. His father, Ray, climbed out of the rental with the deliberate movements of a man who considered himself important and expected spaces to rearrange themselves around him. His mother, Sandra, stayed in the passenger seat for a moment, looking at the farmhouse through the windshield with the particular expression of a woman who is already planning renovations. My daughter got out of the back seat. She looked like she hadn't slept. Howard, my son-in-law said, not walking toward me but standing by his truck as if he owned the ground under it already. Good. You're here. We need to talk. All of us. I said good morning to everyone. I asked if anyone wanted coffee. His mother said she'd love some, her voice carrying that airy quality of someone who expects to be waited on. His father said nothing, already walking the property line with his eyes in the way that I recognized from our phone call. We went inside. I put on coffee. My son-in-law sat at the kitchen table and pulled out a folder. It had the logo of a development company across the top, Webb Ventures, Chattanooga, Tennessee. I want to lay this out clearly, he said. He had dropped the chief in the warmth entirely. This was his business voice, and it was, in its own way, more honest than anything else he'd said to me. I've been in discussions with Marcus Webb for 4 months. He's offering fair market value plus a 20% premium for the development rights. He paused. He's also offering a lifetime residence agreement that lets you stay in the farmhouse. You wouldn't have to move. You'd have the money and your house. What is there to object to? I looked at my daughter. She was looking at her hands. And Claire? I asked. She supports this, my son-in-law said, before she could answer. This is what's best for the family's future. This land is sitting idle when it could be. It is not sitting idle, I said. I grow fruit on it. I employ 2 men. I sell at the market. I have a waiting list from 3 restaurants. He shook his head with the practiced patience of a man explaining something to someone who is being deliberately slow. Howard, an orchard. In this market, you're talking about retirement hobby money. We're talking about something that could set up Claire and the kids for the next 20 years. You're not going to be here forever. And when you're not, do you know what happens? Estate lawyers, probate, taxes. That property gets tied up for years while the family fights over it. This is clean. This is now. This makes sense. I noticed he never once used the word mine. He never said my land. He had been saying you the whole time, but what he meant was mine. He had already transferred ownership in his own mind. The conversation he was having with me was not a negotiation. It was a courtesy notification. I poured myself a cup of coffee. I poured one for my daughter. She took it without looking up. "There's someone I'd like you to meet," I said. Right on cue, I heard tires on the gravel. Patricia Okafor walked through my front door carrying her leather portfolio and wearing the kind of composed professional calm that fills a room the same way certainty fills a room quietly, completely. She was dressed for a courthouse, not a farm, and she was carrying a document case that looked exactly as official as it was. My son-in-law stared at her. His parents, who had drifted in from the porch, went still. "Who is this?" he asked. "My name is Patricia Okafor. I'm an attorney and the legal chair of the board of the Callaway Agricultural Heritage Trust." She set her portfolio on the kitchen table beside his development folder without ceremony. She glanced at the Webb Ventures logo and didn't react to it. As of 3 weeks ago, this property, the farmhouse, all outbuildings, and all 83 acres of land was irrevocably transferred into the ownership of that trust. The trust is now a matter of public record, registered with Blount County and the state of Tennessee. A conservation easement with the Tennessee Conservation Fund is in final processing. The kitchen went very quiet, the kind of quiet that has weight to it. My son-in-law's father put down his coffee cup. "What does that mean exactly?" he said. "It means," Patricia said evenly, "that this property cannot be sold. It cannot be subdivided. It cannot be converted to any use other than the working agricultural operation it currently is. These restrictions are permanent and irrevocable. They survive your father-in-law's lifetime. They survive your wife's lifetime. They attach to the land itself, not to any individual owner. No future trustee, no future heir, and no developer, regardless of what letters of intent have been drafted, has the legal authority to lift them." My son-in-law was on his feet. His face had gone through several colors in rapid succession, confusion, then calculation, then the raw, ugly red of a man who understood he had been outmaneuvered and was not handling it graciously. "This is not legal," he said. "This is not possible. You cannot just—" He turned to me. "You cannot just sign your own land away. You can't do that. This is fraud. This is—" He opened the Webb Ventures folder as if something in it would dissolve what he'd just heard. "It is entirely legal," Patricia said, in the patient tone of someone who had anticipated this exact reaction. Mr. Callaway had every right to transfer his property into a trust of his choosing. He was under no contractual obligation to any third party at the time of transfer. If Mr. Webb entered into informal discussions with your client without first securing a formal option agreement signed by the legal property owner, that is a risk, Mr. Webb's advisors should have flagged. My son-in-law looked at his father. His father looked at the floor. Sandra was standing in the doorway with both hands on her handbag, and the expression on her face was the expression of a woman who had driven 4 hours on a Saturday, expecting to spend the afternoon planning her retirement home. My daughter still hadn't looked up from the table. I stood up from my chair. "I want you to hear something," I said to my son-in-law. I kept my voice even the way I kept my voice even in 38 years of contract disputes and structural inspections and project meetings where someone was wrong and needed to know it. He went still. I told him about my grandfather. Not a long story, not a sentimental one. Just the facts. Earl Callaway, 1,931. 300 miles for peach seedlings. 12 years of railroad savings in his pocket. Hands that understood what work was. I told him about my father, who added the apple rows and built the barn from timber cut on the land, who told me that stewardship was the word for what we did here. I told him about Margaret. He had met her. He had sat at her table and eaten her food and been kind to her in the careful way that people are kind to people they intend to use later. He knew who she was. He knew this farm was the dream she didn't get to fully live. And then I looked at him steadily. "You told me this land was a tax liability," I said. "You told me it was sitting idle. You told me the conversation was going to happen whether I was in the room or not. So I made sure I was in the room. I have been in every room this land needed me to be in, and I was in this room before you even knew the game had started." His jaw was working. No words were coming out. "This land doesn't belong to me," I said. "It belongs to the people who made it, and the people who will come after, and to every living thing that has made its home here for 90 years. My wife understood that. I understood that. The only person in this room who ever saw it as a number on a page was you." His father made a sound that might have been clearing his throat, or might have been something else. Sandra had retreated fully into the hallway. Patricia was still, her portfolio closed, her hands folded. My son-in-law looked at me for a long moment. Then he looked at his folder with the Web Ventures logo. Then he said something quiet and vicious that I will not repeat here, picked up the folder, and walked out of my kitchen. They did not leave that day. Pride is a strange thing. It keeps people in rooms long after they should have walked out, making them pretend the situation is still recoverable when everyone, including them, knows it isn't. My son-in-law spent the afternoon on his phone, on the back porch, talking to someone in a low and controlled voice. His parents walked the orchard in a bewildered silence, Ray occasionally gesturing at things: a fence line, a tree row, with the proprietary habit of a man whose plans have been disrupted, but who hasn't fully accepted it yet. My daughter sat with me in the kitchen for most of that afternoon. We didn't talk much. I made lunch. She ate a little. At one point she said, "Daddy, I didn't know he'd already talked to the developer. I didn't know he was that far along." "I know," I said. "I should have listened better. I should have—" I put my hand over hers, the same way I had when she was small and upset about something she couldn't fix. "Some things you learn late," I told her. "What matters is what you do when you finally know." The days that followed were difficult, in the specific way that a process of ending is difficult, not dramatic, but grinding and uncomfortable for everyone present. My son-in-law drafted something, with his father's help, that he seemed to believe constituted a legal challenge to the trust. Patricia reviewed it on a phone call with me Tuesday morning and said, in her precise way, that it demonstrated a fundamental misunderstanding of how conservation easements work and would not survive initial review. She sent a brief, formal response to the email address he had used. I never heard back about it. Patricia arrived the following Saturday for the first official board inspection. She brought Marcus Webb from the extension office with her. They walked the property with clipboards, measuring labor log compliance. My son-in-law's father had been assigned to assist with clearing invasive privet from the creek boundary, a task that required kneeling in wet soil and cutting stalks by hand. Ray had produced approximately 90 minutes of documented work across the previous 7 days. The minimum requirement was 25 hours per week. Patricia issued a formal written notice of non-compliance. She read it to all of them at the kitchen table, in the same level professional voice she had used to read the trust provisions 3 weeks earlier. First violation. A second would result in a 72-hour notice to vacate. Sandra looked at the notice as if it had personally insulted her. "This is absurd," she said. "We're family." "You are guests of the trust," Patricia said, not unkindly. "Your relationship with Mr. Calloway is personal. Your relationship with this property is governed by the charter." My son-in-law didn't say anything. He was looking at a fixed point somewhere above the kitchen window with the expression of a man recalculating. They left on a Wednesday, 11 days after they arrived. No moving truck this time, just the 2 vehicles, loaded and gone by mid-morning. Ray shook my hand at the door, with a grip that was trying to communicate something, and failing. Sandra walked past me without a word. My son-in-law paused at his truck. He looked at me the way people look at you when they're trying to find the version of events in which they are not entirely at fault. I've seen that look in construction disputes, in failed contract negotiations, in conversations with men who built something wrong and needed someone else to be responsible for it. I didn't give him what he was looking for. He got in his truck and drove down the gravel road, and the sound of his tires on the gravel faded back into the ordinary sounds of the farm: birdsong, wind in the peach leaves, the distant sound of the creek. My daughter didn't leave with them. She stood in the driveway after the vehicles disappeared, her arms crossed over her chest, looking down the empty road with the expression of someone who has just set down a very heavy thing. Then she turned around and looked at the farmhouse, and at me standing on the porch, and I watched something shift in her face, Not relief exactly, but the beginning of it. She walked back up the porch steps and sat in the rocking chair beside mine. For a long time we just sat and listened to the farm. "Dad," she said finally. "I'm right here," I said. She didn't say what she wanted to say right away. That was all right. I had learned from Margaret that the most important things almost always need a moment before they're ready to be said. I spent the last 2 years, she said slowly, telling myself that I just needed to manage things better, that if I said the right things to both of you, found the right middle ground, it would stop feeling the way it felt. She paused. But there isn't a middle ground between someone who respects something and someone who doesn't. I just didn't want to see that. I told her that was one of the hardest things to see when you love someone. That it doesn't make you weak to have tried not to see it. It makes you human. She was quiet for a while. Mom would have seen it, she said. Your mother, I said, saw everything eventually. But even she had a few things she had to circle around for a while before she could look at them straight on. She just did it faster than most. Claire almost smiled. Almost. What she would have loved, she said, nodding toward the orchard, is that it's protected now, that nobody can touch it. That's why I did it, I told her. Not for me, not even for you, though you're part of it. I did it because she had a vision for this land that was better than what I would have had on my own. And protecting that vision is the only way I know how to keep talking to her. My daughter reached over and took my hand the way she used to when she was small. We sat there while the afternoon moved across the orchard, and the shadows of the peach trees stretched long and quiet across the grass. The farmhouse stood behind us, unchanged, unhurried, belonging exactly where it was. My grandfather built his first home on this land with his hands and his savings and his faith that the future was worth preparing for. My father planted trees he would live to see, bear fruit. Margaret named every wildflower along the creek and believed, right up to the end, that the place would always be there to be named and known and loved. I signed 11 pages and kept every promise I ever made. Some men fight with anger and volume in the expectation that the world will clear a path for them. My son-in-law was that kind of man. I used to think men like him were dangerous because they were strong. I understand now that the opposite is true. They are dangerous because they mistake loudness for strength. And by the time they realize the difference, the door has already closed. I am 65 years old. I have 2 good hands, a working orchard, and a piece of land that will grow peaches long after my name is only a signature on a founding document in a green cover with gold lettering. That is not nothing. That is everything. If you were standing in my work boots that morning, what would you have done? Tell me in the comments. And if this story meant something to you, share it with someone who needs to hear it today.